One.
Good afternoon, everybody. This is your favorite here, Grant Kaplan, or Grant Kaplan, depending where you come from. I'm sitting here on a wonderful Friday afternoon in Florida, United States. For those who don't know me, as I've said, my name is Grant Kaplan. We have the Office of Immigration Law Office of Grant Kaplan, Immigration Attorneys. We're based in Boca Raton, Florida. We service and help clients throughout the United States and throughout the world. Our office consists of 3 attorneys and 14 paralegals, all burrowing away diligently, preparing visa applications, green card applications, and various other aspects relating to immigration. You can get hold of us at any time at usvisasandgreencards.com. You can get hold of us on our office telephone number +1 561 347 8440. And you can get me on my private email address, grant@gkaplanlaw.com. So that's Grant, Grant, at gkaplanlaw.com. So we're going to be discussing a number of topics today. And again, we are live, so I would like to get feedback from everybody. Please let me know how we're doing. This is very much an interactive session that I wish to discuss with you guys today. So any comments we're going to be looking at periodically from time to time, and let me see immediately who's on and who's not on, and give us a like. Tell us what it is that you like. I see Chris has already come on and given us a like. Thanks very much, and we'll be able to interact on that fashion. Also, if there's any comments or you think we need to discuss something else, by all means please tell us. And as I say, we'll go through all of these together. So again, office telephone number +1 561 347 8440. That is a 24-hour number, and there are removal related matters and other urgent matters after hours. That is will connect to my cell phone, no problem at all, and we'll be able to assist you guys. We're very much proactive in this firm, and we seek to offer solutions for our clients. We've been doing this a long time, and we'll be happy to help, happy to offer some insight and to give you a realistic assessment of your situation. So today we're going to be talking about a number of different topics, because as you probably have heard, immigration moves very quickly in some areas and stays frustratingly still in other areas. So as far as the areas that we are mainly going to be focusing today on, these are EB-5 investment visas. These are the latest visa bulletin to tell you where you're waiting in the line insofar as certain visa applications are concerned. And then we're also going to be talking about removal related matters. So that's really where we are. I see Imtiaz from South Africa is saying hello, and Rian saying hello. Hi guys, please give us a thumbs up, give us anything positive. Do not give us middle fingers or any other nefarious things. We have enough to deal with over here, as you can probably imagine. Now, the developments as far as immigration are concerned, generally speaking, are not positive by their very nature. One aspect that is popular, and we may have discussed this briefly in our last session, is the visa bulletin. Certain visa categories have moved up fairly substantially, which means that the waiting time for certain people in certain categories have moved up as well. So if, for example, you are a permanent resident and you are filing for your spouse, typically you would have had to wait well over a year before your priority date is reached. In other words, your time within which you could file for a green card. Now the situation is resolved to the extent that these are current. In other words, there is no waiting time, and all is good as far as that is concerned. So you in other words, if you're a spouse, if you're a permanent resident and your spouse is in the United States with you in status, you could immediately file for their green card as well as only filing for the alien relative petition. So these are positive developments because they are pushing ahead with processing times as far as immigration is concerned. So that saves people time. Similarly, if you are filing for a green card through an employment-based visa, in other words, an employer is filing a labor certification for you to live and work in the United States. Once that labor certification is approved, those dates are current at the moment for second and third preference categories. In other words, for people who've got bachelor's degrees or higher. So these are all positive developments, and I would suggest and implore you that you should move immediately ahead with these applications. Have a look, by all means, inquire with us to see if by any chance you are part of these categories, and we will be able to assist you, we'll be able to file for you, we'll be able to do all things necessary for you. Again, our email address, grant@gkaplanlaw.com. You can also contact us on the phone, +1 561 347 8440, and by all means just send us a comment on Facebook, and we'll be able to respond to you as well. So there are questions coming in to go ahead with. Somebody, Wesley, wants to talk about selective service and various other topics. So certainly we can do that, and I'll get to all of those in due course. Whilst we're on that, I might as well just tell you that selective service means that people of a certain age, and I believe it only relates to men, and I think it's 18 to 26 or maybe something of that nature at the time that you file for your naturalization, also must register for selective service. In other words, you need to put in an application to file together with your naturalization application, which makes you essentially a volunteer, in inverted commas, eligible to serve in the U.S. Armed Forces. And yes, that is obligatory to do, and everybody does need to do that. And by all means, if you need more information about that, please let me know. Sylvester is saying that, what do you mean by moving ahead immediately with an application? That means that if you are eligible under the visa bulletin at the moment, and the visa category is current, that means that you can proceed with the next step of the immigration process. So if you've started the process, that means that you can go ahead. If you haven't started the process, you should start that process, whatever it might be, for a family-related petition or for an employment-related petition. Go ahead and file immediately for that, because at the moment the door is open as far as priority dates are concerned and current dates are concerned. So that relates to the selective service, that relates to the visa bulletin. I want to talk now about developments over the last week or two. And the first I want to talk about is what is known as the EB-5 visa. And the EB-5 visa is an investor visa, where at the moment investors can invest a minimum sum of $500,000 in an entity known as a regional center. And in so doing, that will enable you, your spouse, and children under 21 to get your permanent residence once the EB-5 petition has been approved. Sorry, I'm just watching Kevin. He's trying to work out the air conditioning here with much success. If you play any more, Kevin, I think the room's going to blow up, so I think just let that one go for the moment. So the EB-5 will allow you to put up your $500,000 either by means of a passive investment or by means of an active investment in your own EB-5 petition, and in so doing, that will enable you to eventually get yourself a green card. So what has changed over the last week is that there have been significant changes to this program, and there has been registered on July the 23rd, in fact, a new regulation which substantially proposes to increase the minimum investments required from $500,000 to $900,000 in what is known as a targeted employment area, or if you are filing with a regional center, in other words, a passive EB-5 investment, that is going to increase to $900,000, and that is going to take place on the November 21st of this year. So what that means is that if you invest now, the sum is $500,000. If you invest after November 21, 2019, the investment amount required is going to be going up to $900,000. And if you're not in a targeted employment area, the investment is going to increase to $1.8 million. So all of that is generally not good news, because anyone that files an EB5 petition is generally not filing to make any money through the investment itself, because the returns are typically pretty low. So there would be no sense to wait until November if you could make that investment now. And my strong suggestion and recommendation to you is that if you are in the market for these EB5 investor visas, that you do so immediately. There is no sense in waiting, and if you can do so, by all means, please contact us if you want to discuss this in more detail. It's certainly possible to do that with us. The amount doesn't only have to be your own. It is possible to borrow that money or be gifted that money, and we can certainly talk about that in some more detail. So again, give us a call or email us. grant@gkaplanlaw.com is the easiest way to do that, and we can certainly talk about that. So of course, all the regional centers are rushing around trying to get the investors to invest before that date. And for your own clarification, a regional center is nothing more than an entity that has got permission from the Immigration Service to take investors to come and invest in a project in the United States. Most of these regional centers are property-based developers, but they don't need to be. They could be in any field, and there are 600 of them. Some of them are what we would call blue chip type entities. Some of them are listed companies, and we'll be able to give you a lot more information about that if you're interested in that, or if you're interested in investing in your own business by investing that money in the EB5 project. By all means, please give us a call. So that is the EB5, and we can certainly talk a lot more about that. There's certain other aspects relating to the regulation that change the definition of what a targeted area is going to be, and matters relating to removing conditions on green cards and so on. Nothing we need to discuss right now unless anyone wants to particularly do so. The bottom line is, if anyone is in the market, or you know anyone else who may be for an EB5, now is the time to act. Now is the time to get involved. Please discuss, please contact us, and we'll be happy to chat to you about that. So that is the EB5 program. We will discuss shortly some other business-related visas. I wanted to move on briefly now to the removal-based scenario. In other words, and I'm sure everybody has seen in the news, the building of the wall, all these caravans of people coming in through the border, requesting to file for asylum and for various other things. And then you no doubt have seen that the president, our illustrious president, has indicated that there's going to be mass raids and creating fear and havoc amongst certain communities. So, of course, people from certain countries typically are more prone to file for asylum and are more likely to be applying for asylum, and may even be coming through the border in greater numbers. So I'd be interested to know, just by the way, where you guys are coming from. Where are you watching from? Please give us an indication. I know that we have viewers from all over the world, and we can give you a like, and we can acknowledge you. I see always we have guys from South Africa, we've got guys from England, we've got guys from Canada, and from various other countries as well. So back to the removal. The Trump administration has promulgated various proposed regulations and various other developments. For example, there is, sorry, I see our watchdog is outside the door there, Kevin. Maybe she's looking to come in. Sashi, the watchdog, maybe looking to come in and see what's happening. No, I don't see her there, but when she comes, we can certainly put her on the camera and see what's happening from there. The Trump administration has expanded what they call expedited removal. In other words, what they intend to do is those guys who have come in without any visa, or who have certain criminal convictions, or who are otherwise inadmissible. The Immigration Service is now proposing through Immigration and Customs Enforcement to put these guys in expedited removal. In other words, you do not get a hearing, you do not have the right to appear before an immigration judge, you simply deported. Now, they want to do this as a sort of a fast-track summary process without any kind of hearing. And for people who don't have valid immigration documents, these are primary targets, or people who have misrepresented material facts, anything like that, or false claims to U.S. citizenship. These people would be amenable to expedited removal. So typically, whereas previously that has usually been put into practice, those guys who have been within 100 miles of the border, they are now going to utilize this practice all over the United States. Really, that's really where they are. So I'm just reading, how this is proposed to be implemented, which is, a substantial expansion of this practice in the past. Also allied to that are people who seek asylum. The Trump administration is proposing to deny any asylum application or not make any asylum application admissible if potential people coming to the border have come in through a third country. So let's say you're from Guatemala and you go through Mexico and you find yourself at the border. The Trump administration proposes to say that you would not be eligible to apply for asylum because you've come through a third country, namely Mexico. And if that is the case, you should go and apply for asylum in Mexico or wherever else you came from in order to get to the United States. So that is currently under litigation, and I think yesterday or the day before there was a Ninth Circuit judge who dismissed that argument. So at the current moment, of course, anyone can still file for asylum. And as a matter of interest, there are all kinds of interesting people who are coming through the border, including South Africans and various others who, for whatever reason, are finding difficulties in obtaining visas or doing something else. So, of course, many of these people are desperate and are seeking to come in whichever way they can. My view is that, of course, anyone should be given a hearing. Even if it's an expedited hearing, everybody should have their day in court. Everybody should have their chance to explain to the Immigration Service and to an immigration judge what their factors are. And of course, if there is no basis to apply for asylum, then by all means, deport and do whatever they need to do. So I don't have any difficulty with that. But of course, everybody must have their day in court. Everybody must be able to come in and have their say and get a fair hearing as far as that is concerned. So there are various questions coming in, including from Indy, who wants to know if one can file for naturalization if you've traveled out of the United States for 1 month. Yes, naturalization really allows you to be obtained once you've had a green card in the United States for 5 years, and you could be out for up to 6 months at a time, as long as you are not out for a continuous period of more than 6 months at a time in the United States. And so that's really what that's all about. So let's move on to some of the other topics. Generally speaking, from a business immigration point of view, the same regulations apply. We spend a lot of our time helping guys do L1 visas, intra-company transfer visas. If you or your family has a business, or you are a senior employee in a business and you've been employed in that business for at least 1 year in the last 3 years, and that business is a viable business in your country, that will make you eligible to come across to set up a branch or subsidiary in the United States and be transferred across to come in and set up and operate that business in the United States. Does not need to be in the same business. There is no minimum capital investment required. You do need to show that you have sufficient money to set up and operate the business and be viable and to draw a salary and to obviously provide a viable business other than to provide employment for yourself. So we still spend a lot of time working our way through those visas, and we'll be happy to discuss these and any other visas with you, and any other green card options that you may have. Again, my email address is grant@gkaplanlaw.com. Telephone number +1 561 347 8440. And so, yes, I'm just having a look at some of the other comments that are coming in, and I'm looking at all the likes, and certainly things are going well as far as you guys are concerned, and happy to answer any further questions. So once you, just a clarification on the naturalization question, the gentleman was asking, once he had either filed for or obtained his citizenship, whether he could travel for a period of 1 month. The answer is yes. As long as you have a green card, you can travel up and down as long as you're here for your interview and or your naturalization oath ceremony, no problem as far as that is concerned. Very briefly, some other visa categories: the E2 visa category, investor visa category, if you're from certain countries with whom the United States has a treaty with, mostly European countries, Canada, some countries in South America, and other random countries. If you can invest at least $100,000 in a business, you may be eligible to obtain an E2 visa. Certainly nothing much has changed on that. The consulates are adjudicating the E2 visas on a much stricter basis. Everything now has to be lodged electronically with them. They only take a limited number of pages electronically, so that package has to fit within that scenario. And again, we can assist you with that. So that is the E2 visa. There are various other employee visa categories: H1 visas, labor certifications for green cards, trainee visas. Happy to discuss all of these with you guys, no problem whatsoever. The overriding impression that I want to leave you guys with is that regulations have got much more difficult. Everything is being adjudicated on a much stricter basis. So the attorney's work is doubled effectively to get the same result. I always say there is no warm blood flowing at immigration. You have to do your work over and over again and make sure that all the facts and all the documentation and all the information is correct. The officials at the U.S. consulates typically have an unreviewable discretion. So any time that you appear before any immigration office, but particularly at the consulate, you need to make sure that all your documentation is in order, that you've covered all the requirements that they may be requesting, because once they deny you, if they were to deny you for any reason, of course, there's an unreviewable discretion. You cannot take them to court. You can certainly file again. You may need to speak to a congressman. There's various options, but typically they're not very palatable to do. The other question which we are asked frequently is, what if I've overstayed previously, or what if I have a conviction for something, or what if I owe the IRS money? Issues like that may or may not be waivable. In other words, certain issues we could file waivers for and be forgiven effectively, and therefore you could get your visa or your green card, and certain cannot. So for example, I had a consultation earlier today with some people for someone who's sitting in Chrome Detention Center, which is in Miami, and this gentleman, from what I could understand, had a conviction which appears to me to be particularly serious. If that conviction has been sustained, as they tell me it has, that may make him what is known as an aggravated felony, an aggravated felon in immigration terms, and that may limit his ability to file for any kind of waiver or any other kind of relief. So it's very important when consulting with any attorney to provide all the facts, to provide all the information, all documentation as much as possible, so that we can properly advise you. And you could therefore not be surprised, unpleasantly surprised, unfortunately, usually, when dealing with immigration. In many occasions, we attend interviews with our clients, both locally and at consulates and at the immigration court, and the client has not given us all the information, or the client misunderstood, or the client innocently or otherwise misrepresented facts on the application. Again, as I've indicated, the USCIS is very thorough at their job. They have access to all kinds of information, including IRS records, criminal records, Department of Motor Vehicle records, and everything else. So it's essential that we be given all the information so that we can advise you properly and file properly on your behalf. In many cases, there is a solution, and we can certainly help you to find that. So that's really where we are, guys. I'm just having a look to see if there's any further comments here. There seem to be. I see some guys are writing. Some guys are asking about the O1 visa, which we've already discussed, and we're getting some likes. Thanks very much. And we can also help you with your naturalization applications. You know, once you've got your green cards, if you're married to a U.S. citizen, if you are applying for a labor certification, if you're applying for your naturalization, by all means, please contact us. Again, I'm going to give you our number, +1 561 347 8440, and you can email us at grant@gkaplanlaw.com. And please mention this to whoever else you may know to tune in. You can look us up on the Facebook page, US Visas and Green Cards, anytime. The videos are live. There's quite a lot of information there. You can contact us at any time on that page, or contact us directly. As I say, we're pretty proactive. We'll be happy to help you, and we look forward to hearing from you. So from Kevin and myself, cheers. See you later. Have a good weekend. Thanks very much.